DOMITILLA, from screen character to trademark battleground. Hi there, welcome to this podcast where I'm delving into a legal saga that has shaken Nollywood to its core. It's a story that began nearly 30 years ago with a groundbreaking film and ended up in a courtroom. Back in 1996, veteran producer Zeb Ejiro brought to life the cinematic blockbuster DOMITILLA. The movie became a cultural phenomenon, telling the story of a young woman's struggle in Lagos. At the heart of that film was the unforgettable performance by the lead actress Chioma Njemanze, who played the title character so powerfully that the name DOMITILLA became synonymous with her. She was the face of the brand, a household name for decades to come. The tension began in 2020 when Zeb Ejiro announced a modern reboot of the classic film. He approached Njemanze for a role, but when negotiations stalled, he decided to move forward without her. That was when the tables turned, and Njemanze, through her lawyers, issued a cease and desist letter, claiming that the film was an infringement of her intellectual property. You see, she had already taken a bold step. She had filed the trademark DOMITILLA and device herself just a month after the reboot was announced. This created a legal showdown that went straight to the trademarks tribunal. The question was not just about the movie title, but about the ownership itself. Does the brand belong to the creator who conceived it, that's Zeb Ejiro, or the performer who gave it life and in the public eye became its most famous representative, as Njemanze? This case forces us to re-examine the delicate relationship between an artist's creation and the legacy of a performer. Join me as I explore the facts, the legal arguments, and the implications of this landmark ruling for every creative person in Nigeria. So, I'm going to go into the breakdown of the case, starting from when he went to the tribunal. The trademark was filed and registered in the name DOMITILLA and device in Class 41 on September 16, 2020. The trademark was published in October 2021 by the Trademarks Registry. This publication marked the formal announcement of the trademark, initiating the period during which oppositions to the trademark could be filed. The petition by the petitioner Zeb Ejiro was filed in February 13, 2023. That was more than a year after the official publication. So the Trademark Tribunal ruled on May 4, 2023 in favor of Zeb Ejiro, revoking Chioma Njemanze, DOMITILLA and device trademark, siding with Zeb Ejiro, who was deemed the rightful owner due to his prior and continuous use of DOMITILLA brand since 1996. However, the dispute did not necessarily end there. Njemanze filed a lawsuit at the Federal High Court in Abuja against Ejiro, Film One Entertainment, and Tribe Media, alleging infringement of her trademark and seeking to set aside the tribunal's decision to reinstate her. She also sought to reinstate her trademark and claim 50 million naira in damages plus 5 million naira for litigation costs. Ejiro's legal team described her challenge as dead on arrival, arguing the tribunal's ruling was final, and Ejiro also filed a counterclaim against Njemanze for breach of confidence. There's no definitive public record in the provided sources confirming whether the Federal High Court case was resolved, dismissed, or settled out of court by September 2025. Some reports indicate the Federal Trademark Registry had scheduled May 4, 2023 for a potential settlement report, suggesting an attempt to resolve the dispute amicably, but the tribunal's ruling proceeded when no settlement was reached. Beyond this, no further updates confirmed the outcome of Njemanze's appeal or any subsequent legal actions. So, the tribunal ruling, which ruled in favor of Zeb Ejiro, finding that Njemanze was not the true proprietor of the DOMITILLA trademark. I'm going to give like a breakdown of the court's decision. So, the tribunal rejected the first-in-law argument, instead relying on the common law principle of force to use. It held that DOMITILLA, the movie, which gave rise to the trademark, was created and produced by Ejiro, proving his prior use. Also, the tribunal found that Njemanze acted in bad faith because she was well aware that Ejiro was the owner of the trademark and her association with the name was as a result of his work. The tribunal did not rule on the jurisdictional challenge raised by Njemanze regarding the elapsed opposition period. Instead, it cited Section 22 subsection 1 and Section 18 subsection 7 of the Trademark Act, which allows the registry to correct errors and withhold registration when a trademark is accepted in error. This provided the legal basis for its jurisdiction to arbitrate the matter. The tribunal refused Njemanze's application, cancelled the acceptance letter, and declared that she was not the owner of the Domitilla's trademark. That was the outcome of the case. It highlights the distinction between the two forms of intellectual property, that is copyright and trademark. Copyright, in this sense, protects the original work itself, that is the movie Domitilla, and ownership vests with the producer Zeb Ejiro. Copyright does not protect single words or titles, while trademark protects a name, symbol, or device used in commerce to identify and distinguish goods or services. The name Domitilla for entertainment services. Ownership belongs to the true proprietor who uses or registers the mark. The case raises questions about the relationship between these two legal areas and suggests that future legal frameworks in Nigeria could benefit from provisions clarifying the link between copyright ownership in a work and the trademarking of its elements, such as character names. I mean, we can't put aside the case of Njemanze. Let's let's delve into the decision of the court concerning the case in favor of Njemanze. One would argue that she followed the law and the tribunal's decision was an overreach based on the following point of law: legal certainty and the first to file system. The court defense for Njemanze hinges on the first to file principle, which is the foundational basis of trademark registration in Nigeria. While the Act doesn't use this exact term, it is the operational rule. A legal team would argue that by the following of the legal procedure of filing and getting an official acceptance, she had a legitimate claim to the mark. Zeb Ejiro's failure to register the mark for over 20 years, even with his prior use, meant he had slept on his rights. One could also argue procedurally, using the expired opposition window. A crucial procedural defense is that the tribunal should have lacked jurisdiction. Section 20 of the Trademarks Act establishes the 2-month period for anyone to file a notice of opposition after a trademark is published. Njemanze's team would have argued that since Ejiro's petition was filed long after this window was closed, the matter was statute barred. The tribunal, however, bypassed this argument by citing Section 38, which gives it power to rectify the register if an entry was made without sufficient cause, or Section 40, which allows for the correction of errors. Njemanze's defense would have challenged the tribunal's use of these sections as a means to circumvent the statutory opposition period. So the ruling in the Domitilla trademark, which favored Zeb Ejiro, despite his lack of a registered trademark, is a well-reasoned decision that aligns with the fundamental principles of Nigerian trademark law. While Nigeria operates a first-to-file system, this principle is not absolute and is subject to crucial exceptions and common law doctrines that the Trademarks Tribunal correctly applied. Some of the Nigerian laws backing this rule, I'll be breaking them down. So, we have the proprietorship by prior use. The core of the ruling rests on the principle that the true proprietor of a trademark is the person who first uses it. Nigerian law, as established in a long line of cases, acknowledges that a person who has been using a mark in connection with their goods or services since inception has a superior right to that mark, even if another party registers it first. Zeb Ejiro, as the producer of the movie and the owner of the copyright, had been using Domitilla name in commerce since 1996. The tribunal rightly found that this long-standing prior use made him the true proprietor. Also, we have bad faith registration. A registered trademark can be invalidated if it was obtained in bad faith. Section 11 of the Trademark Act prohibits the registration of any matter that is likely to deceive or cause confusion or is entitled to the protection in a court of justice. By applying for a trademark for a name that was well known to be associated with a movie franchise created and owned by someone else, and Njemanze's application was deemed to be in bad faith. She had a prior relationship with Zebejuro and knew the origin of the name, making her attempt to claim it for herself was a dishonest act. Unregistered trademark and common law. Although the Trademarks Act grants exclusive rights to registered marks, Section 3 of the Act explicitly preserved the common law right to bring a person-off action. This is a legal remedy available to owners of unregistered trademark to protect their goodwill and reputation from deceptive use by others. While Ejiro's action was a petition to the tribunal and not a person-off lawsuit, the underlying principle of protecting prior use and goodwill remains the same and informed the tribunal's decision. And in relation to Nigerian laws backing this ruling, I'm talking about well-known marks. Nigerian courts and tribunals are increasingly recognizing the concept of well-known marks, which are protected regardless of whether they are registered or not. The Domitilla brand, having achieved significant fame and public recognition in Nigeria for nearly 3 decades, qualifies as a well-known mark. This notoriety grants it a higher level of protection against third-party registrations, especially when such a registration is made in bad faith. So, in my opinion, the tribunal's decision was not only legally sound, but also a victory for justice and fairness in Nigeria's creative industry. Allowing the actress to hijack a name made famous by a producer's work would have set a dangerous precedent, a very dangerous one, discouraging investment and creative collaboration. The ruling sends a clear message that the Nigerian legal system will not be a tool for opportunistic trademark squatting, and that a person who puts in the creative work and establishes the goodwill has a stronger claim to be a brand name than a mere first-to-file applicant. So that's basically all to learn about the breakdown of the Domitilla's case, its impact and effect on the Nigerian creative industry, and the application of trademark laws to the case. Thank you for listening.